all set to begin.
Thank you. Thanks. All right, I'll call to order the Zoning Board of Appeals meeting for Wednesday, June 12th, 2024. To all persons interested in or affected by the action of the Zoning Board of Appeals are hereby notified pursuant to Section 11 of Chapter 40A of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing of the following appeals will be held today, Wednesday, June 12th, 2024. First, introduction of board members. Mark Hanson.
Present.
Herb Bodenseek.
Present.
Paul Pinard.
Present.
Larry Hurwitz.
Sorry, present.
Manny Alves is absent. Denise Johnson's absent. And Aaron Webb is absent. And I'm Jacob Dewey. Notice of recording. This meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is recording this meeting, and if so, please make their presence known. Seeing none, the first order of business is minutes from April 24th, 2024. Anyone have any comments or want to make a motion to approve? No? I'll make a motion to approve the minutes from April 24th, 2024.
Second.
All right, and all those in favor?
Aye.
Aye. All right, so the minutes are approved. We have no old business tonight, so we go straight to new business. Appeal number 2024-017, 518-556, Yarmouth Road LLC is petitioned for a variance pursuant to Section 240-61C. Prohibited signs. Recent building construction includes a functioning lighting provision serving to outline portions of the building, which was deemed a violation by the building commissioner. The petitioner seeks to allow the provision previously installed lighting to remain. The subject property is located at 556 Yarmouth Road, Hyannis, Massachusetts, as shown on Assessor's Map 344 as Parcel 076-001. It's located in the Business B zoning district, and sitting on this tonight will be all members present. Mr. Ford, Attorney Ford.
Yes, good evening, Mr. Chairman, members of the Board of Appeals, Attorney Mike Ford, representing the applicant. The 556 LLC, and with me is Joe Laham, who is the manager of the LLC and the owner of the property. Some of the board members, with the exception, I think, of Mr. Hurwitz, are familiar with the fact pattern that brings us here. This was a situation where the lighting at issue was built into the building. It was part of the original building permit, by way of background. And in the course of the plans being reviewed by the building department, it was not part of any sign permit. It was approved and subsequently installed. And once the building was up, everything was installed, an occupancy permit was issued, and the lights started to be used. There was a complaint by a third party, and the building commissioner ultimately issued an enforcement order finding that some of the lighting on the front of the building, it was tube lighting around two windows and a front piece, was indeed a sign under a particular section of the bylaw that prohibits lighting of this fashion because in the definition of the bylaw, if it draws attention to the building, it is a sign, even though it doesn't have any symbols or lettering or words on it. And so we appealed that decision by the building commissioner, and before we appealed it, we made an effort to resolve it with the building department, and I told this to the board last time, but I think I need to get this all on the record again tonight, Mr. Chairman. And what Mr. Laham did, as I said, there were two tube connections to the lighting in the three spots, and he disconnected one of the tubes so that there was only one tube left. And then he installed a dimmer and used the dimmer to reduce the lighting of that one tube down to 50%. So really from the original lighting that the enforcement order issued on, I guess it's really a reduction of 75%. But there's only one line or tube left that is not disconnected, and that has a dimmer on it, and I'll get to a proposed restriction that we're offering tonight as part of this proposal. But having done all of that, the building commissioner's opinion was unmoved. He still thought it was a sign, and so we came here, pled our case, And the board, while sympathetic, it seemed like on two fronts. One, the fact that this was already approved by the building department and installed, and two, that we had made every effort to try and dim the lighting so as it did not draw attention more than the other lighting, which is legal, that's already there. But the board was hesitant to overturn the building commissioner, and the board was also hesitant, given the nature of the appeal that was before you, is the building commissioner right or wrong, to get into the whole notion of the reduction of brightness and the dimming and so forth. And so as a result, the board upheld the building commissioner. And during the course of the hearing, a couple of board members indicated that if it had been before them in a different fashion, for example, a variance as it is tonight, then maybe they could have had some discretion to see whether they could have gotten into the whole issue of brightness and dimming and come up with a decision that might have allowed what is still left out there and to be used to remain. So the decision was issued by the board. It became final. We did not appeal the decision, but we have brought for the board's consideration now a variance request. And what I'd like to do, Mr. Chairman, is to go through what I believe are variance conditions that the board could consider in this particular case in order to review the matter once again and with a restriction, perhaps find that the three-prong test, and of course the three-prong test for a variance is conjunctive. We've got to meet all three. It's not disjunctive. But I think you can meet the prongs here. So the first one, owing to circumstances relating to soil condition, shape, or topography of the land. We don't have any soil condition, shape, or topography of the land in this particular case. But then it goes on to say, or structures. Don't often use that phrase, but it's in the first prong. It's in 40A Section 10. So the unique conditions can apply to structures, and especially affecting the structures, but not affecting generally others in the zoning district. So I indicated to you that the structure in this particular case, in that the lighting, now deemed to be an illegal sign, was approved through a building permit process. The type of lighting, which was properly approved and installed at the site, has now been determined to be a sign, which would violate 240-61C under your prior decision, which upheld the building commissioner. This is a unique condition that exists at this building. I suggest to you that it doesn't exist in other buildings around. It was arrived at through a process that, frankly, was not the fault of the applicant, nor the town for that matter, as they were not really reviewing the building permit plans for a sign. Nobody thought this was a sign. Nobody knew it was a sign. And so I'd suggest that we do have a unique condition, and that unique condition relates to the fact that this lighting is present there, had been approved, and however, under number 2, the second prong, if you apply the bylaw literally to these facts, it creates a hardship. Why? Because if you apply the bylaw literally, the signs can't be used. The signs are the lighting. The lighting can't be used, notwithstanding the fact that it was paid for. It was significant financially because it was built right into the building itself and as part of the facade. So I'd suggest that you can find that a little enforcement of the ordinance, which arises from the unique condition that it's already there, does create a hardship to the applicant, a financial hardship in this particular case. And that's the second prong. Third prong, and this one's a little more complicated because of what I'm going to suggest could be a possible condition. Desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent and purpose of the ordinance. I'd suggest here that you can find that it would not be a substantial detriment to the public good or nullify the purpose and intent of the bylaw if, in fact, the lighting that is permitted to remain is used in such a way that the illumination does not draw the attention of the public such that it really is a sign. But since the board has found it as a sign, that ship has sailed, And so what we're seeking here is to offer a condition. I sent the proposed condition in. I hope you have it. If you don't, Mr. Chairman, I have copies. I could pass it around. Okay.
You have it, yes.
So the condition I'm suggesting is, as I said, there were 2 lines to these, and perhaps could we bring up the first one on that, the first picture. There were 2 sets of pictures. I'm not sure it's that one. What do you have after that? There's one single one, and there's one with 3 on it.
This has 4 on it.
That is 4. Okay, so the last one I sent to you today is the one that needs to come up first. Okay, so you see, that's the one for which the enforcement order was issued. And you'll see the outlining of the 2 window areas and the outlining of the front. And that consists of 2 lines of tubes of lighting. Looks like one when they're all lit up together. And that's the brightness that caused the issue and caused the enforcement order. So now we go to the next picture. Thank you, Anna. So here it is, and this is now just 1 tube, so it's a lot thinner. The other one is disconnected. And he has a dimmer on this, so that these are dimmed to 50% of the 1 tube. And that's what we're offering as a condition, that if you grant the variance, the sign could never be used at an illumination, the brightness of which would be more than 50% of the illumination capacity of what is currently installed. And we've just got 1 line installed, the other one's been disconnected. This is on a dimmer, and that's down to 50%. And so how does that fit under the 3rd prong? That allows, if it's properly conditioned, to allow you to make a finding that this would not nullify or substantially derogate from the purpose and intent of the bylaw because it doesn't have that bright illumination which caused the enforcement order, which was one that you made a finding last time, as the building inspector did, that it drew public attention to the point where it was a sign under that particular section of the bylaw, which I think is rarely used, but was applied in this particular case. So that your finding there could be that a grant would not be substantially detrimental to the public good and really wouldn't nullify for the purpose and intent of the bylaw with the reductions that we're offering. So kind of a compromise, if you will, but one that we're offering because we realize no one's entitled to a variance, and they're issued sparingly. You've got to meet a strict statutory test, and frankly, I don't think we could meet prong 2 here without some sort of mitigation, and that's why we're offering the condition with respect to prong 3, criteria 3 of the variance. So that's our case, Mr. Chairman. We're happy to take questions. Mr. Leham is here as well.
Thank you. Does anyone have any questions for the applicant? No questions? All right, we'll open for public comment. There was 2 letters from the same person. One that was in opposition, referring to this as looking like we were in Vegas, and then one rescinding that. I'm not sure the history of why it was rescinded, but we received the 2 letters. And is anyone here to speak to this? No? All right, I'll make a motion to close public comment.
Second.
All those in favor?
Aye. Aye.
So that closes public comment. Does anyone have any thoughts before we close the public hearing? I mean, it's a variance ask, and it's a stretch. It's a stretch. I mean, again, I push back.
Bring it back to the board?
Yeah.
Oh, go ahead.
I don't see how it meets condition number 1.
Is your mic on?
I'm not sure how it meets condition number one, due to the topography or anything. I just don't see that. I do understand the fact that it's existing, and that it wasn't picked up or anything, but I think that's a whole nother question. I don't think that pertains to number one.
Paul?
The subjective question is what draws to the attention of the public? In this, I mean, if someone said, by a meter, 100 feet from the thing, it's 100 lumens or something like that, then I think you could be consistent upon everybody who came in with, because this probably won't be the last one, or couldn't be the last one. I don't know how to apply this to other applicants or would-be applicants. I don't know how to enforce this across the board. And so I have a problem from that aspect of it.
Mark?
Yeah, again, a question on one, struggling a little bit with the topography of the structure. I understand the topography of the land, but we're dealing with there's no obstruction, there's nothing. I do understand that it's existing, and I guess that would be, I don't know if it's topography, but it does exist in its current form. Obviously, I don't think that the interior lights, just as a general comment, I don't think the interior lights draw any more attention than the exterior lights dimmed, but still we're trying to find the variance findings here, and looking for something a little more substantial on number one.
Could I address that, Mr. Chairman, or you want me to wait?
Let's just finish here. Herb?
Yeah, well, maybe this is what you were going to say, but I think that it pertains to the shape, not of the land, but of the structure. And I think adequately dimmed like that is there, irrespective of the lighting that inside the store. I don't think you can even look at that as part of the whole thing. And then, I mean, if you look at that amount of lighting now, dimmed as it is, and then remember the fact that you're on Willow Street, you're driving down Willow Street at night, so you're going whatever the speed limit is, because God knows we wouldn't exceed it. So you're going 35 miles an hour or something. I personally don't see the problem. And it's not because I'm trying to, fit a square peg into a round hole. I really do think that it's a shape factor and a structure factor. And it has to be both. It could be more, but I think that's adequate right there. Anybody else?
I mean, I struggle with one, I also struggle with three, because you're looking at the intent and purpose of the zoning ordinance, and the zoning ordinance says strictly prohibited any display lightings by strings or tubes of lights, including lights which outline any part of a building or which are affixed to any ornamental portion thereof, except for temporary holiday lights. So our bylaws are very specific to this being prohibited. So I have a little bit of an issue with derogating from the intent and purpose. I mean, we can't go back to what town council, why they decided that this is what they wanted in the bylaw exactly, but it's how it's written, and we are clearly derogating from that. So I have a little issue there, and I think one is a long stretch, but I hear Attorney Ford where he's going with it. Attorney Ford, you want to respond to
Yes,
all of us?
if I could. Thank you, Mr. Chairman. So first, when we were here last, I went back and looked at my notes. 4 out of the 5 members who were hearing this said, if this was here as a variance, we could see our way to perhaps do something here. But since it's simply an appeal of a decision of the building commissioner, then we feel we can't get into lighting and dimming and reducing it. And so if it was here under a different form, we might be able to give the relief that you're seeking. Now, we can't take that at the bank. We understand that. Variances are difficult. But that's the reason we're back, frankly, is the discussion that occurred during the last hearing. So, with respect to variance conditions, Mr. Bodenseek is correct. Topography has nothing to do with this. Topography doesn't have to have anything to do with the first prong. It only applies when the unique condition is related to the land. Same thing with the soil conditions. Same thing with shape, although shape can apply to a structure, because all three of those say topography, soil conditions, or shape of the land or structures thereon. Well, obviously, topography and soil conditions don't and cannot apply to a structure. So it's just shape that applies to the structure. These lights are unique in terms of their shape, and they've become unique, frankly, by the process by which they were allowed to be put there. So I think, number one, you can make a finding on. Mr. Chairman, with respect to the intent of the bylaw, you read the part that describes the light. However, in order to even fall under that section, you first have to be a sign. So a sign, in a definition, is any temporary light, and so we've got the light, okay, but beyond that, it also has to be something that advertises, informs, or attracts the attention of the public, and which is designed to be seen from outside a building. So last time, we had a long discussion about this, because I said, look, you can't just jump to the lighting section and say, oh, that type of lighting is prohibited. It has to be a sign in order to even get to that section. So we talked a lot about this last time, and you agreed with me that it really isn't being used to advertise, it isn't being used to inform, but it was attracting the attention of the public, which is what the building commissioner thought it was. So I reasoned that the way that you could grant a variance and it would not be nullifying from the purpose and intent of the bylaw is if we took away that level of attraction to the public. We've reduced that by 75%. Again, if you go to the first picture, could you put that first picture back, Anna? So there it is. And that's what you found attracted the attention of the public. And because it did, it was a sign. And if it was a sign, then you went to that section that prohibits the type of lighting that this is. But you never get there unless it's a sign. So what we've done now, if you go to the second picture, we've reduced the level of attention of the public by simply dimming it down by 75%. And as a result, I'd respectfully suggest we probably fall out of a sign, which is what I tried to argue last time, but you said, we're not going to get into dimming. If this was here under another form, we could do that for you, but we can't do it in the form that was in. So now we're back in the discretionary form, and I'd suggest that having done that, you could now grant this, and we're not derogating from the purpose and intent of the bylaw because, frankly, we've dimmed it to the point, if you'll take a look at the brightness of other things on the building, where that's not the focus, that's not the attention of the public any longer. It was when it was 2 lines of lighting and at that brightness that it was, and that's what you found. So now we're back, and we're suggesting that with that condition, you could find that we don't nullify from the purpose and intent of the bylaw because we've reduced the attraction to the public, which was what made it a sign in the first place, and because it was a sign, this type of lighting is prohibited. So that would be my response, Mr. Chairman.
I guess I still struggle, though, Attorney Ford, because you're asking for a variance pursuant to Section 24061C, which is recognizing it as a sign.
Yes, because you
Now you're telling me it's
found
not
it
a
was a sign. You found it was a sign. We didn't appeal that. So there's a finding by not only the building commissioner, but you, that it's a sign. So now I've got to convince you that being a sign, how can you give us a variance without nullifying from the purpose and intent of the bylaw? I go back to it and I say the reason it's a sign is its brightness. So if we can address that issue with a condition, then it won't nullify from the purpose and intent of the bylaw. That's how they fit.
I'm still struggling for a path. So then we would determine that it's not a sign and we're not touching 24161C?
No, you've already determined it's a sign. You would say
You're saying by changing the dimming of it, it's no longer a sign.
No, it's not. That ship has sailed. You found it. You didn't want to get into dimming last time, and I get it. So now we're back with a variance, and we're suggesting a condition that I think you can allow on a variance and make a finding that it doesn't nullify the purpose and intent of the bylaw, because the purpose and intent of the bylaw was to outline signs that were that bright that it caused the public attention. We've addressed that with this condition, so we're not nullifying the purpose and intent of the bylaw.
But the sign bylaw is saying any display lighting by strings or tubes of lights, which clearly it is. Whether it's a sign or not, it's display lighting by strings or tubes of lights, correct?
Correct, but you don't get to that section unless you are a sign under the first section.
But that's what you're asking for a variance from. You're asking for a variance from that exact bylaw.
That's right.
So you're saying we don't get to that bylaw, but you're asking for a variance from it.
No. I'm not saying you don't get it. What I'm saying is you have to read it as a whole, Mr. Chairman. You can't just say, okay, we got string lighting. What is the whole bylaw? You got to read it together. And the bylaw together is, this is a sign because of these reasons. All right? Since it is a sign, is it an illegal sign? Yes, because it's string lighting. And I'm trying to address what the issue was with string lighting and the brightness in this case by the condition. And that condition, I'm reasoning, would allow you to make a finding that it isn't running counter to the purpose and intent of the bylaw.
Does anyone else have any thoughts? I want to get there, but I'm just having a hard time.
Well, frankly, that was the suggestion that the board gave me during the last hearing.
Let's close it off and bring it back to the board.
Okay, does everyone have all the information they want from the applicant? You want to make a motion to close the public hearing?
Yeah, I'd like to make a motion to close the public hearing.
Second.
All those in favor?
Aye.
Aye.
So the public hearing is closed.
Okay.
All right. Board members.
Yeah, I look at this and whether I have to go from, I look at the whole 24061C. I don't say if I go from here, then I have to go from here, then I go there, but I can't go here. I looked at the whole thing, and it states specifically, outline of a building is prohibited. That's what it says. And what other intent could there be other than they don't want a building outlined in lights? I'm sorry, but I don't know if XYZ came in here tomorrow and said, well, I dim my lights 80%, you know, why can't you should prove mine? Well, I don't know how do I know? You know, I'm one judge. Does it draw the attention of the public? I don't know. It certainly draws the attention than if there weren't lights. So that's where I'm standing.
Anyone else? Go ahead, Herb.
Going back to number 3, on further inspection, it says without nullifying or substantially derogating from the intent of the zoning ordinance. I don't think it's substantially derogating. I just have a hard time because it has cost, it must have been a considerable amount of money from, you know, from our perspective, you know, being homeowners probably that we are, and it just seems like it should be approvable.
Again, it's finding a path here. If you feel comfortable finding a path, I encourage you to present it to the rest of us.
Well, it can be granted without substantial detriment to the public. Would we agree on that?
I agree on that, but it's also and without nullifying or substantially derogating from the intent or purpose of the zoning ordinance.
Yeah, nullifying or substantially derogating. It doesn't mean
Well, you're eliminating
nullifying at all.
But you take that whole thing out of the.
I mean, the bylaw, unfortunately, is very clear. It doesn't say any display lightings that affects the roadway or that, you know, is, you know, affects neighbors or something of that nature.
it's a
It literally
narrow
says that
definition.
the council said, we do not want any lights on buildings. For better or worse, that's, you know, that's above us to have made that decision.
Well, it does fit that description for sure.
It says, including lights which outline any part of a building. Which unfortunately, that's what these lights do. I don't think we can argue that they don't.
But that's what variances are for, to allow for exceptions from zoning ordinances.
Following the three-prong test, which I don't feel like we can follow. So then it goes back to the council to amend our sign code to properly
I, for
address
one-
future construction.
I don't think it's substantially derogating from the intent.
Well, how does it pass number 2?
Substantial hardship, financial and otherwise, I think that's the one that it definitely does pass.
It's already there.
Yeah,
Well,
we got past number 1, I think we can
so
agree
if
on.
it doesn't work, what's the hardship? The money spent.
Well, you'd have to turn it off, and I don't know if you'd have to uninstall it, but
They turn the switch off. You know,
it costs a lot of money, and now it won't be
well,
used.
what, turn the switch off?
Well, I guess what you're saying, it won't cost any further money, because it's already been spent.
Well, that's what they're asking for, a variance for now. From point in time, right?
Because it was approved by the town.
Well, there's that, too. That's a separate
That's
issue, I'm
not on
sure.
us.
Mark?
Mark, any thoughts?
I was only going to just try to add some clarity to one. More that my understanding that topography of structures can also include orientation. And in this circumstance, the structure is already in place. There is no other way to reorient the lights to focus in another direction as far as gaining attention. So it does, I don't know if it's a unique circumstance, but certainly the orientation of the building and the inability to turn it or move it might help us with the number 1.
So does anyone want to make findings? Larry, do you have any thoughts?
Well, like I said before. And I think other people have agreed that I don't see how it meets the first prong at all. I understand that someone has gone through considerable expense trying to reduce the impact of this, but that was before it was even brought to us. Okay, so, you know, that's difficult for me to understand. You know, I don't think it detracts from the neighborhood. Okay, that I can, you know, get myself to, you know, understand that, because he's reduced the you know, the lumens out there by dimming it and eliminating some of the lighting, right? But it's got to meet all three, and I just don't see how it meets all three of them.
Okay. Attorney Ford, it's starting to seem like we don't have a path here. Do you want us to take a vote on it, or?
Could I just have one moment with
The
my
hearing-
client?
Yeah, sure. The hearing's closed.
Because that talks about casting direct light.
Any sign or lighting which casts direct light or glare upon a property in residential. That's about casting in residential.
Well, but if you read that section, it also puts you back into residential. It has to meet all the residential requirements plus that.
Mr. Chairman?
Yep.
I thank you for the opportunity to consult with my client. Not being a math major, but I can certainly count. I would ask on behalf of the applicant if you would allow this to be withdrawn without prejudice at this point.
All right. I'll make a motion to have appeal number 2024-017 withdrawn without prejudice.
Second.
All those in favor?
Aye.
That is
Thank you very
withdrawn.
much.
Thank you. All right, moving along to new business, appeal number 2024-018, Stephen J. Clifton-Constantino, trustee of the Clifton-Constantino Living Trust, has petitioned for a lot area variance pursuant to section 240-11 RB, RD1 and RF1 residential zoning districts and section 240-125 zoning board of appeals. The proposed subdivision will reestablish the same lot lines as prior to the 1985 merger and will be legitimized with an approval not required in our plan. And if approved by this board, the subject property is located at 37 Goodview Way, Barnstable, Massachusetts, as shown on Assessor's Map 319 as parcel 080. It's located in the Residence B RB zoning district. Attorney Tardif, do you want me to read the second one in at the same time?
I was hoping we could handle
Okay.
both of them together. That'd be great.
All right, so we'll do this concurrently. Appeal number 2024-019, Susan E. Murphy and Richard Senoski have petitioned for a lot area variance pursuant to section 240-11 RB, RD1 and RF2 residential districts and section 240-125 zoning board of appeals. The proposed subdivision will reestablish the same lot lines as prior to 1985 merger and will be legitimized with an approval not required and our plan. If approved by this board, the subject property is located at 57 Goodview Way, Barnstable, Massachusetts, as shown on Assessor's Map 319 as parcel 081. It's located in the Residence B RB zoning district. So sitting on both 2024-018 and 2024-019 will be all members present. Attorney Tardif.
Thank you very much, Mr. Chairman. Members of the board, I'm Paul Tardif. I'm an attorney in Yarmouth Port, and I do represent both the petitioners on those two concurrent hearings, and I thank you, Mr. Chairman, for allowing me to address both of them. I kind of feel that they go together, and I think one affects the other. So these and the parcels are actually depicted up on the plan. I'm kind of glad we had that plan today to try to put this piece of puzzle together for you. So they abut. They're in the RB zoning district. The 37 lot, which is the triangular, I'll call it triangular-shaped lot on the curve of the road there. That's a bare lot having approximately 8,300 square feet or so. Has 164 feet of frontage on Goodview Way. The 57 lot is the rectangular lot just located a little northeast of it. That has about 14,000 square feet of area, 140 feet of frontage on Goodview Way, and is currently improved with a 1.5-story single-family dwelling which was built in approximately 1935. I want to tell you how we actually got here. So the owner of the 37 lot, Mr. Constantino, who also owns the property that abuts it to the west. If you look over there, you can see it's actually 38 George Street, which is, they back up, the two backs hit each other. George Street is the parallel street to Goodview on the other side. And that has a house on it that is owned by Mr. Constantino's trust. He contacted me recently to see if we could determine whether the 37 lot was a buildable lot by itself. And what I do at that point is we start the analysis to determine whether under the zoning ordinance section 240-91, which is the non-conforming lot section, and we're looking for the single lot exception. So we go to section A, and in order for a lot to qualify for that, first of all, it has to be unimproved, which this one is. It was must have at least 5,000 square feet of area and 50 feet of frontage, which it does. It conformed to the existing zoning, if any, when legally created, and this, well, we'll get to that, but I can tell you it does. Was not held in common ownership with any adjoining land. And I read that to mean that it was not held in common ownership when it was created, and was separately owned at the time of every zoning change, which made it non-conforming. Understand also that these two lots are registered lots with the land court, and this is the western side of a subdivision that abuts the eastern side of a separate subdivision. So the George Street property comes from one section. These land court properties come from a different development. According to the information that was provided to me by the Barnstable Office of Planning and Development, the 37 lot, again the triangular lot, and the 57 lot, the rectangular lot, were originally located in something called the RA1 zoning district, which was created in 1956. And from that date until 1971, the minimum lot area for parcels in the district was 7,500 square feet. So at that point, up to 1971, we were good. They were created. They actually met the zoning requirement. In 1972, the zoning district was amended and was called the RB zoning district, which is what it is now. And the minimum area requirements were increased to 10,000 square feet. So we went from 7,500 square feet to 10,000 square feet. And then the subsequent amendment was in 1985, and that bumped it from the 10,000 square feet up to acre zoning, just so you have the timeline there. In this case, the properties were created as part of a land court plan dated October 11 of 1944. So when it was created in 44, these were laid out and approved. They all met the zoning requirements and met the minimum lot requirements for the zoning district until 1972. And as I indicated, the 37 lot, which is the triangular lot, has about 8,500 square feet or so. So in 1972, when they bumped up that zoning to 10,000 square feet, that is when we have to determine whether it was held in common ownership with another lot. And so we started going through the analysis to find all the different lots that it touched and who owned it at the time and whether or not a merger had occurred. Because, as you know, merger occurs when we have non-conforming lots that the law feels, if they're held by the same party, will push them together to make them more conforming or fully conforming. So that was the first time that that occurred, in 1972. I did the analysis on 37, Goodview, which is the triangle lot. I did the analysis on 38 George Street, which is the other property owned by Mr. Constantino currently, and also the 57 Goodview, which is the rectangular lot, in 1972. And I found that there was no common ownership at that point. In my estimation, everything's fine. We still have grandfathered rights for the 37 lot. But then we go to 1985. And 1985, again, is when we went to acre zoning. So we have to take another look at that time, take a snapshot of 1985 and see who owned what at the time. And it was at that point that we found that there was common ownership. To our dismay, the ownership, well, it was not common between 37 and Mr. Constantino's other lot. It was actually common ownership with the rectangular lot. And in 1985, it was owned by a husband and wife. Again, that house was there. I don't know if they lived there or not, or whether they even knew about merger. But it was in 1992, so about 7 years later, that they conveyed these two lots out in the same year to different people, strangers. One bought a house lot, and one bought a bear lot. They eventually came into ownership by Mr. Constantino for the triangle lot, the rectangle lot purchased by Ms. Murphy and Mr. Senoski. I can tell you it was quite a surprise to them as well when we contacted them and said, we have a zoning issue. It's not a big issue. It's not like everyone owns all of the lots together. But what you had here was a combination of lots, and instead of going through the subdivision control law and going to the planning board and asking for that line to be put back in there so the deeds could be separated, they just deeded the properties. And it happens, I hate to say it more often than not, that people just don't know. And so we did what they call a subdivision by deed, which is not permissible, which is why I'm here. So we've reached the point where we want to legitimize these lots again. And basically that lot line that you see there between the triangle lot and the rectangle lot is the lot line that is on the land court plan that I referenced from 1944. What we're trying to do is put that thing back. So we just basically go back to square one. I'll go 1984, not 1985, so that the homeowners can start acting with their lot and do things with their lot that they want to do, and Mr. Constantino can do what he wants with his lot. So our plan was that we are going to prepare, we have prepared an approval not required plan, which is what you see here. Before we can go to the planning board and ask them for permission, we obviously have to come to you and ask for a variance for each of these lots, because by drawing that line, we will have lots that do not meet the minimum lot requirement for the zoning district in which we are sitting, which is an acre zoning, and neither meets it. And after the last hearing with variances, I know you're all warmed up, so we won't bore you with a lot of the details, but I can tell you that I believe that we do meet the variance requirements for this circumstance, and it's a little bit different than the last hearing. With regard to a hardship, I think it's very simple to find hardships in this case. I can tell you that Mr. Constantino purchased that lot, the triangular lot, the bare lot, for a little under $200,000. I can tell you also from the assessor's field cards that he is being assessed, he's being taxed on a property that is assessed at $780,900 as of today. The rectangular lot, also purchased by Ms. Murphy and, get my clients right, Mr. Senoski. They paid a little under $700,000 for that house that is 89 years old. And the current assessed value on that property is $1.2 million. The land alone is $832,000 that they pay taxes on. And basically, they are handcuffed at this point because they can't do anything with their properties until this variance, or if this variance is granted. If they do want to do anything with regard to construction, expansion, or anything, they need a variance from this board. And as you know, the variance criteria are very, very strict. I can tell you in this case that the rectangular lot, the intention of that owner is to leave it exactly as it is. There is no intention to do anything. That is not how this came about. For the triangular lot, I can tell you that Mr. Constantino, as I indicated, would like to have constructed something on that lot for his family. We are hoping, even though if a variance is granted here, it does not make that a pre-existing non-conforming lot just by the issuance of a variance. Obviously, it cannot be. And so it would not be a separately buildable lot. However, the intention would be to have an additional dwelling unit, an ADU, constructed there for his family so he could enjoy that with them. Again, he has the house on George Street, and that would be a location where he could put that. That's the only intentions at this point, and that's just why we're before you. The shape, the soil topography, again, I read it a little differently than you, and I don't think I guess on the triangular lot, we do have some argument about shape in that case, where we have a developer who decided to bend a road right there at that lot and wrap it around, and by doing that, shorten that lot considerably. And as for the house lot, again, I read that as saying that there are circumstances affecting the structure, and I think in this case, it really does affect the structure because they are now foreclosed from really doing anything with that property unless they have a variance. And then the last criteria, which I think makes this a little bit different, is this. The bylaw would typically allow these to exist. Number one, a house lot, the rectangle with the house on it, is allowed in the zoning district in which it's located. It's a residential, it's a single-family lot, and that's all they really want to do with it. They purchased this thing thinking that everything was fine. It's not. I can tell you it's not a routine exam that comes with any type of title search when you're purchasing a property. But it was only an illegal lot based on the deeding of the lot and the circumstances relating to it. If you also look at the equities in this case and see what we're trying to do is to redraw that line. Neither of these applicants before you caused this problem. Neither were the ones that did anything. In fact, they were long after the fact owners of the property. Both properties acted as if the lots were never merged, and they've acted that way. You can see, if you looked at some of the plans for the improved lot, they've always had a measurement from the side of that house to that lot line. That's always been their thought, that that was their lot line, and that's what they want it to be. The house lot is the house lot is potentially subject to a special permit, the structure itself. Under Section 7 of 40A, it's been 10 years since those deeds went out in 1992, so the town would have had 10 years at that point to do anything. They haven't, but still, we wanted to come and seek the variance because that is the way that this is properly done to correct this issue. And again, these are residential lots. So I think that we meet the criteria. I think these criteria apply differently in this case than they did in the last case we heard. I think that by doing this, I think we're going to get people back to where they thought they were in the first place. And I guess that's all I really have to say. If you have any questions, I hope I can answer for you, and I appreciate your time tonight.
Thank you, Attorney
Thank you.
Tardif. Does anyone have any questions? Go ahead, Mark.
I guess my question is sort of moving back to in the variance conditions, variance number 1, we're still looking at this as soil, shape, topography, the hardship, the actual hardship. Not that it's been sold one way or another, but based on that alone, where is the hardship?
Well, the hardship is in the fact that they've paid so much money for these properties. Financial can be a hardship, and that would be in. No, I'd say that's in number 2, not 1.
But everyone's paid that much money for a lot in that area. You just told us that. So it's not an outlier. We need an outlier.
It is when you can't do anything with it, and that's the difference here. That's what makes this unique, and I think that's what one of the requirements are under this three-pronged test. The owing to circumstances, it says, relating to the soil conditions, shape, or topography of such land or structures. I read that as owing to the circumstances related to the structure. And in this case, you do. You have a structure. How unique is this? You have a structure that no one can do anything with in a neighborhood full of houses that are being knocked down and rebuilt routinely. And I think, it's not their intention to do that now, but that alone, their failure to be able to do something with an 89-year-old home would be, without a doubt, a hardship, and it's owing to that structure. The other lot, I think, has a lot to do with the shape on this property. You have lots of frontage, but very little area, and I think that's where this went sideways. This was a sort of an extra lot that was buildable when created, but merged not with the intended party, with the unintended party, and I think that's what makes it unique.
So you're saying we had to find a hardship for both of them here, too. So your argument of a hardship for the Murphys is that they are sort of stuck with this thing attached to them from a zoning perspective, or?
Yeah, if they wanted to knock a garage down on that property and come back, they have to come back before this board for relief. If that was a legal or pre-existing non-conforming lot, and they could put that structure on the lot in such a way that they wouldn't need any relief, there is a difference in there, and that's what makes them different from other properties. Here, anything they do, any replacement needs a variance. That is an illegal lot. It's created by deed, and it's not permissible. And I can tell you that my discussions with the planning department have confirmed that, as well as the building department.
And then Mr. Constantino is getting benefit of Lot 37. It's being well used. It's not like it's not usable for a purpose currently.
It's not usable as it is.
Well, he's using it as his backyard, clearly.
If you want to find utility in a backyard rather than,
Well, it's not overgrown. It's not like,
It's
you know,
not.
it's not operating like a vacant lot, is all I'm saying.
It's a vacant lot for which he paid exorbitant amount of money, and now he cannot, and he's being taxed on it as such, and now he cannot do anything except maybe kick a soccer ball around.
Well, he wants to put an AD, eventually, to put an ADU on that lot?
That's
Why
right.
can't he do it now?
Because it is a illegal lot.
Why then are the deeds legal?
I'm sorry?
Why are the deeds legal?
Well, the deeds go on record to put people on notice of ownership. But in the eyes of the law, under the merger doctrine, those two lots combined at one point. And
37 and 57.
I'm sorry?
You're saying 37 and 57
Oh, I'm sorry, yes,
combined.
yes.
Right, yeah, right, okay. And then they were sold.
And then they were sold out.
So they
And
were
then
merged, they were sold,
Separately.
They were merged, then sold.
then how are those deeds valid, is my question.
because deeds, a deed putting someone on notice at the Registry of Deeds and paying consideration for land that is described, that is a valid deed. The circumstances that come with it, however, are what we're dealing with today, and that's not known. That's not typically done in a title search. It's a considerable amount of extra work that has to be done. Again, all we're trying to do is put this back to the way everyone thought it was, and I know that. And I know we need a variance for both of them. I do think this is different, and it's unique. I don't think we're giving something away, and I don't think we're rewarding someone for doing something improper in this case. I think these people were complete innocent parties on this, and they just want to get back to where they thought they were.
Any other questions?
It states in there that the O'Reilly plan referenced is dated April 17th, 2024. There's no date on this plan, though.
On this plan?
Yeah. I couldn't find one. But, so is this the one? I mean, I'm surprised there's no date on here, or I can't find one.
Yeah, I can't see it from here. I can barely see anyway. But, I can tell you that the plan was submitted to the planning board, but they were told that we need to come here first and see what you wanted to do about it, so. But that would be the A&R plan, is to create that lot line right there. Is it in there?
Could I ask a quick question while they're looking at that? So the original lots that you said were not in common ownership before the 1985, sorry, I always mix these dates up, but before that date when they clearly were together, were they two completely unrelated separate parties, or was it an individual and a trust, or was it an individual? Was there any relation between a trust or a beneficiary or anything along that line?
They weren't. I wish
Okay.
they were. It was I believe it was a husband and wife or father-daughter. I don't know the relationship. But they came in 1985, and then they were conveyed out, and 7 years later, separate deeds. They also came in as separate deeds. So when they bought them, someone bought the triangle, someone bought the rectangle separately, and then they sold them separately again as the triangle and the rectangle.
So the original lots, even before 1985, those were never in common ownership, not by trust, not by beneficiary? Okay.
Nope.
All right, do we have any members in the public to speak to this? I don't think we received anything. We'll open public comment for that. Seeing none, I'll make a motion to close public comment.
Motion to close, public comment?
Someone want a second?
Second?
Second.
All those in favor?
Aye.
Aye.
So public comment's closed. We need to find variance for both of them, too. We need to make sure if we're moving this, that both, we can pass all three prongs on both of them. I mean,
Are we
it's a
in
hard situation
Board
here.
discussion phase here.
Yeah, the public hearing's still open if we wanted to ask anything else.
I'm just at a loss for, the lots were merged, but basically nobody knew about it.
That's correct.
Just doesn't,
Well, that happened to a lot of lots.
It's happened.
in that
It
time.
happened back
happened,
then,
yeah.
yeah. This was-
Until you
this
find
reminds me
them,
of,
until you dig them up, you don't know that they're merged. We find them frequently. There are different bylaws that treat them differently. All the locals are allowed to treat them differently, but it all goes back to the common law doctrine, and then your bylaw does have that same basic provision in it, so.
I could see it going through several different ownerships and, is this a title insurance issue maybe?
It can be, yes, yes. And I mean, I've dealt with a number of them in Yarmouth mostly, some in Dennis as well. And again, you never know when they're going to creep up, because it's not something that, it's not like the town says, your lots are merged, or someone comes out of the state and says they're merged. You have to look at all the facts and then plug them in. And it's usually when people are looking to do something that it's revealed.
So really, this isn't about the use necessarily of 37. This is the inability of 57 to do what they want with their lot.
It's really both, because I don't think he could get an ADU on that lot because it's an illegal lot. Until we make it legitimized, I don't think that the building commissioner is going to give me any relief to do anything over there.
But he clearly has use of it.
Yeah, I mean, it's not like he can't step on it. Yes, it's
Yeah.
his lot, yeah, but it's sitting, correct.
And so if we grant this, those lots are going to merge. 38 George and 37 Goodview are going to merge.
Yeah, the intention is that if the A&R that you're looking, or if this is the plan, I think it is, if the A&R is approved, the triangular lot will be taken out of the registration system at the land court because George Street is recorded land, which is a different registry, and then they will be merged on an 81X plan to become one lot. So it's not like it's going to be, sold out separately under the ADU. That's probably the benefit of it, is that there's going to be one owner of, if there's going to be an ADU, it's got to be one owner on there. So that's the intention.
So it's not automatic. You're saying if the variance were granted to go back to the original line, separate the lots, that still does not automatically, therefore, even though they're common ownership now, of 57 of a 37 and 38, that doesn't automatically merge them.
It does not,
What's protecting it? Because of
because of the
registered?
lot line. Now, you could make an argument that, the use of the property, I don't know if there's a fence there or what, but you could make an argument, and the building commissioner could make an argument that the two of them have merged by the fact that, there's a septic system maybe on that lot. I don't think there is. I think it's a standalone lot, but that the use of the lot as one residential lot has become that. But we're going to do that anyway with an 81X. If you want to make it a condition, we can. I can tell you that that is the plan.
Well, okay, if you have two lots, 38 and 37, that are owned by the same people, what's this about a lot line or something? I mean, they're merged, right?
They're not merged.
They're not legal lots by the fact that they
They
peeled them
both
off.
have to be legal lots.
It would have to be a legal lot.
They are two separate lots at this point.
Well, okay, fine.
Yes.
But created in a way that was not legal. 37 and 57 Goodview were created illegally.
Correct.
Which
But-
is why
but
they
with regard
can't.
to the property on George Street, there's two lots. But as we stand right now, it's not that everyone owns both lots. It's that you have two lots that were created illegally. It's like drawing a line across a plan and saying, you take that, I'll take this.
Okay, since we're considering both of these together, what's the hardship with 57 if the variance is not granted?
Yeah, there's a variance, there's a hardship on 57, the house lot, correct?
Yeah,
Yeah. So they have an illegal lot, which was revealed to them about 2-3 months ago. It was a really fun phone call, by the way. So because of that, if they wanted to do anything on their lot, anything, addition, knock something down, build something, they need a variance from this board to do anything. That's not a grandfathered lot at this point. That's an illegal lot. And so what we're trying to do is establish that lot line and have the variance allow, what would we call this, a lot area variance?
Please, I just want to make sure I
Sure, sure.
understand this, okay? If nothing happens, okay, legally, 57 and 37 are merged, correct?
They're still merged today. Yes, in the eyes of the law, they are one lot.
Okay. And 57 can therefore do what they want because the acreage is such?
No, they don't even meet the acreage.
Okay, I understand.
Yeah.
So whether we grant the variances to break the lots up, there's no impact on 57 one way or the other.
Well, there is. I mean, by granting a variance, you are now drawing that lot line, reestablishing the boundary that they thought they were getting, and legitimizing the lot. If at that point, because the lot was created pursuant to a variance, Whether they wanted to do something with the house at this point, whether that would be a special permit or a variance would be something for the building commissioner. I can tell you the house is pre-existing, but the variance sometimes taints the entire lot, and therefore you need a variance for anything.
It basically it rewinds the clock back to 1985. It unmerges the lots. It's just going backwards. It unmerges the two lots so that they become
If-
legal.
If nothing happens,
Yep.
in other words, the variance is not granted, okay, then 57 and 37 are merged
In the eyes of the law, they are, but they
Zoning,
did.
okay.
From a
but they
zoning
do have
perspective.
from a
separate-
zoning perspective.
Yeah.
Okay, so therefore, whatever 57 wants to do would be the same requirements stringent otherwise as if it were granted the variance.
This is just an easier path, correct? I mean, if they wanted to build or they wanted to change something, they would still come for a variance.
Yep, they'd have to come
So
for a
what's the
variance
hardship?
and,
I'm trying to
Sure.
understand the hardship to 57 is what I'm trying to get at.
sure, they are handcuffed, because if the lots are legal, the house is illegal. If the lot is not legal, if the lot is legitimized by a variance tonight, it's possible that the house is grandfathered because of its age. So if you wanted to do anything with the house, they could possibly do that. But what we're trying to do is legitimize the lot now and just go back to 1984. These applicants are just trying to go back to the time they got the deed.
No, I understand that.
Yeah,
one of
so,
the-
but it's an extra step for them.
The major a major test of the variance
Mm-hmm.
is a hardship.
Right.
And in this case, with respect to 57, I'm just trying to understand what's the hardship, whether the variance is granted or not. And I'm not sure what the hardship is.
Because it's a legal lot. If they wanted to do anything on that property, they have to come back to you. And they're going to have to reestablish all variance criteria for their lot.
I don't understand.
Why is 57 illegal, exists as it is?
Because it merged with 37. And then a deed was created, or two deeds were created, one for each lot, to convey them out. And when they did that, they didn't do it properly, because you cannot divide a property by deed. You can only do it by approval of the planning board, and they didn't do that.
So the deeds aren't valid?
I'm sorry?
The deeds aren't valid?
The deeds are valid, yeah. They run on two different tracks.
Okay.
Yeah.
Well, you're
Yeah,
expert.
the ownership is there. It's the circumstances that flow from those deeds that are really, we're trying to fix tonight.
Difficult one.
Yeah, it is.
All right, does anyone else have any more questions or comments? Are we ready to close the public hearing, or,
I
yeah?
think so.
Larry, you good?
I think so, yeah.
All right, I'll make a motion to close the public hearing.
Second?
All those in favor?
Aye.
Someone want to tackle findings on either or both, or?
Well, we're going to talk about it?
Yeah, talk.
Talk to me. What's-
I mean,
Give me a hardship
I'm-
of 57. I want it, I want this, but what's the hardship on 57?
57 is usable and it could be renovated in its current condition. Obviously, if they're looking to do a knockdown rebuild, it becomes more difficult. but it
Potentially,
still
the
does-
property's unsellable, though. It has this, like, thing attached to it that,
only for change from a zoning perspective, correct?
No, it's an illegal lot as we sit here, yeah.
So you're saying 57 can't be sold?
well, I think, in light of what has come forward,
Right.
a title insurance company probably is not going to insure it.
Well, that's a hell of a
For
hardship, I would
a
say.
sale, I assume, because it's not illegal.
So isn't that a hardship?
Potentially, yeah, I think that's where we're
Not a
going.
hardship.
So they couldn't even get a building permit for new windows, right?
I mean,
I doubt it. We haven't applied, and I'm not the building commissioner, but I've seen that before.
Anything that increases the encroachment to the property lines,
I
Definitely.
I had a house that was non-compliant like this, and it was on a cement foundation, and they wanted to just, first we wanted to knock the house down. Couldn't do that. Wanted to just replace the foundation. Can't do anything. Leave it alone. So they were just faced to have the thing fall down.
Well, if there's extreme difficulty, if not impossible,
the,
for 57 to sell the house
Transfer.
as it exists today,
now that they have knowledge
Yeah.
of the situation.
That's, I'm sorry, David. To repeat myself for the record here, if 57 wanted to sell their house today, it's quite likely that they couldn't sell it because of the existing problem now with the deeds.
It would certainly be an impediment. You need to find the right buyer. And no bank.
So Paul, that satisfies your,
Satisfies me.
Your-
That's what I said, yeah.
so,
Can it be said that the shape of the lot includes an illegal attachment per zoning? I mean, we have to get to this, like,
This
soil shape
uniqueness.
topography,
We're trying to help you out here.
Well, I
structure.
It's, yep, circumstances of the structure. If you look at the circumstances, that's
But
what
from
it
a
said.
topography
Owing
standpoint,
to circumstances related to soil conditions, shape, or topography of such land or structures.
topography of the structure, though,
Well,
I guess
I
is
read
this-
that as owing to circumstances relating to the structures.
or the shape of the land.
In shape.
What is the recourse here?
Does
Can they go
building,
to court?
did building or planning have any view on this?
They did. I spoke to the building commissioner, who related that he had handled several of these here in his prior days, and that he was quite pleased that we were fixing this problem and addressing it, as was the
Is there-
planning,
Is there recourse here?
what's his name? Kupfer?
if we
Mr.
didn't
Kupfer?
approve it,
Yeah.
Jim?
I don't know. I don't know what the process would be. It would probably be an appeal to the land court.
Yeah.
We're trying to make a decision on lots that are technically not merged, that from a ownership perspective,
From-
but not.
They're, it's,
They're
37 is merged to 57 from a zoning perspective.
From a
but
zoning
From an ownership
perspective,
perspective, it's
they're
No.
not.
operating with 38.
Right.
Correct. This is where we're having, because you're taking one away from the other. We can't say that 57 has a problem with its shape, topography, or any other,
With or without the
with or
attached-
without the
Right.
piece.
That's
There's
like
nothing
we're
wrong
not-
with it. It does not an outlier.
You know, all the lots are the same size and the same,
I mean, I guess shape. I know it's, you look at it firsthand, it's a rectangle, but shape with regard to an interest, going back to 1985, I think there's something definitely unique and affects this land and doesn't affect many others. I mean, it's rare that we have.
I
well,
think,
Sure.
I think I'm trying to see an issue here, and the issue is that 38, because of the shape of the lot, undersized, they can't do anything with it.
It's 37.
37.
37.
but that's not, it's not
37.
an outlier. All the lots in that neighborhood are very similar size. There's not like an outlier reason there that lot's small because there's a stream going through the middle of it or something, or an embankment. There's nothing really unique here, I'm not seeing.
Okay.
But are you talking about 37?
He was talking about 38, George.
Oh,
Very similar to 52 is the same size, 24 is the same size, same shape.
I mean, the 81X that we're going to be filing to combine 37 and 38 George. I know 38 George is not part of this, but that is the intention, and if that's a condition that gets us there, I'd be more than happy to agree to that. And the combination of those two lots would make it quite unique shape, so.
I mean, again, what we're struggling here is with a path, and it's just, these things seem to come to us as the board to fix them, but we don't really have the tools in the toolbox to fix them.
Right.
We're trying to fix a lot that really, on the surface, has nothing wrong with it.
Yeah, on the surface, yeah.
This is a legal issue.
But because of the definition, makes it difficult to say there's another lot that has been sold off that was attached, even if this was we have to get to that
Oh, I understand.
soil shape topography.
Yeah, I'm seeing a legal issue here. I don't know how else to say I could solve this through a zoning ruling. Wish I could, but
Does someone want to make a motion? Does someone, I'm sort of like, my head's against the wall here. I don't know how to see through. I mean, the owner of 37 has a little bit of a hardship, but they don't even, because they bought it as a backyard, clearly.
Yes.
And they're using it as a backyard.
Clearly.
And they're not having a lack of backyard issue. But
If, I mean, it really does come down to more like a title issue. I don't know how it,
so if 57 were approved, in other words, there's two here that want to do the same thing. So if 57 were approved and 37 was denied, you'd still get to where you want to go, right?
Well, that's interesting, because we thought about that, because it's one line between the two lots.
Both want the same thing.
If you were inclined to grant 57 the variance, that would, by implication, leave 37 there to be joined with 38 George.
by default.
Yeah, because by separating one, you technically have done the other. And, you know, it's always been my experience, we did one in Dennis where we wanted to join both owners on either side of the line. One didn't want to go to the zoning board of appeals. So we went with the other and got that. And that effectively cleared well, actually what happened is we didn't clear their property, but then we went back alone after the fact, and it was sort of hard for the board to say no when there was just one lot, and so they did that. I don't want to play games with the board, and I know that, you know, the variance criteria are next to impossible. And a lot of times they don't apply, especially to uses. In this case, you know, based on all the circumstances, and I know you're thinking about the three. I think it's the right thing to do to fix this problem, and I know people come to this board all the time, lay it at your feet and say, help us, and do it. I'm not to that point yet, but we really don't have another method here. And, you know, this board is empowered to grant variances. Every variance does, you know, deviate a bit from the bylaw. I think this one, based on these specific facts, not that this could be followed anywhere else, I really think that this variance is warranted. I think it's, you know, it's not like a self-created hardship where you always want to say, well, you did this to yourself, you know, lie in your own bed, but it's not. And so, you know, if there's a way, we really do hope that you can find your way to grant this variance. Again, you know, I'm not seeing neighbors, I'm not seeing opposition to this in any way in the neighborhood, and we're just trying to get this right.
Okay, anyone have any?
Well, it's kind of all an interpretation of the three criteria to fit the situation. Excuse me. Can shape be interpreted to also include size? I mean, because that's really the issue here, is the size, not the shape, soil condition or topography. And the shape's a rectangle.
whether or not this is saleable is not a zoning issue necessarily. They do have use, they can use, and this is where we're running into the trouble, is the hardship is what can't they do? They can't change it, but they can use it, correct?
They're not prohibited from using their piece of land. They're not prohibited, but they have to use it in that condition.
Yeah, I agree with you, Mark. I think this is a legal issue. It's not a zoning issue.
It's a titling issue, essentially. It's
Yeah, right, yeah.
more than a
Which
zoning
makes
issue.
it
If this-
legal.
I mean, the sale never should have happened from 37 to
Right.
the owner of 38. And this all, ironically, all happened in 2013. It seems like that, not at the same date, so I guess it wasn't the same people, but it was all kind of happening around the same time. But I guess what the sale could be undone, and 37 goes back to 57. But then they still would have to ask for a variance to have it removed, have it cut off.
But then they could break it up, right, legally?
No, because it would be merged. I mean, it is merged with
Right,
57.
but they can ask it to be unmerged.
They would have to come to us to ask to be unmerged. Then it potentially would become a buildable lot. I don't know. I don't have, if someone else wants to make findings and find a path forward, I'm welcome to it. I'm just,
Just don't see one.
We're not trying to not do this. This is,
I get it. I get it. It's not, I mean, I think you sympathize with the situation in which my clients find themselves, and had that phone call not come to me a few months ago, we never would have known.
I mean, no, that doesn't work either.
can I ask what the actual intent is beyond this? Let's say the variance were granted. I'm not saying it is, but
on both?
if it were, no, more on 57. What is the intent to do with the property? Is it a knockdown rebuild? Is it anything? This is just if they
Nothing.
want to do something
They
in the
didn't,
future.
they didn't want to do it. This came, Attorney
Oh,
Tardiff
this
called them and told
Oh,
them.
it came from-
I think it was the owner of 38.
Right, sorry.
Right, that was trying to do something with their
Right.
I
backyard.
understand.
He went
understand.
over,
He wanted to build an
told him
ADU.
something was going on, called me. I had the conversation with him. And
Getcha. Okay.
Yeah.
I'm sorry.
So, no,
Yes.
there is no.
I understand.
He has never said to me, we're putting the 3-story house on this. He never said
I
that.
understand. Okay. Sorry.
He just wants to live his life, so.
And I guess if they were to come back to the board with an application to build something, we're still in the same situation.
And they got a mortgage on it, though, right? I assume.
Yeah, because the title search would have not revealed this.
Correct.
You search the title of the property you're buying, not the surrounding properties, and that's where this goes sideways.
We've had these come up before, but typically there is a very glaring issue with the shape or access. Something becomes a lot that has no street access or something like that. This
Understood.
has everything.
I understand. It's just that you have two parties with intentions. Well, one with none and no intentions, the other one with an intention to do something that the bylaw permits. And that's all he wants to do. It's
So-
the only path to get here.
Do we want to continue, would it help if we continued this and you came back with some more sort of, I mean, I guess, again, none of us are lawyers here, so if you can give us a path that we can sort of agree to, I don't know if you can, or maybe Attorney Kenny can.
So fif-
And just for the record, the public hearing is closed.
right, this is just.
Yeah, no, we can discuss here, I'm just saying, we have to be careful. We may have to open the public hearing if we're bringing more evidence in.
Understand.
That's all.
So 57 now can do whatever it wants to do, whether or not the variance is granted or not. There's nothing much that changes. Whatever it had to do,
Technically, they're sitting on an illegal lot, is what Attorney Tardiff is telling us.
They can't do it.
Because
can't do anything.
they were merged together, yet they don't own the part that was merged,
That makes it illegal.
that makes it illegal,
That makes it a legal problem, not a zoning problem.
potentially, yes. Yeah, like,
Well-
I mean, the real remedy to undo this would be for 37 to be sold back to 57. That's the
Well,
actual,
They were never,
which,
those two parties were never part of the merger. Mr. Kenny just handed me a note saying, he's quite a historian around here more than I am, but he's saying that in the past, the board would would state that they find no 40A Section 10 conditions, but that they'd still grant the relief requested and then put the condition on for the 81X. For what it's worth, we're just trying to find something here.
So we're bypassing our variance findings, but we're granting variance?
Just number one.
Sometimes,
I don't know if we have that authority.
Not after what
I think Attorney Connolly would not be approve of that, but,
Mr. Chair, you do have the option of seeking legal counsel
okay.
from the town attorney.
We could seek legal counsel. We
That
could
would be
consult
helpful.
with Attorney Connolly and,
That's a great idea. Let's
We might seek legal counsel from the town.
is that okay?
yeah?
Anna, do you think if we go out one meeting or two meetings?
Probably two
Two.
meetings and
Okay.
just continue to that date.
All right. So I'll make a motion to continue appeal number 2024-018 and 2024-019 to July 10th, 2024, for a time for the board to get review from legal on the item. Do I have a second?
I'll second.
All those in favor?
Aye.
Thank you, Attorney
Thank you
Tardif.
very much. If you need anything that I can get for you, I'm happy to get it for you, and appreciate your time.
Thank you.
I took up a lot of it,
Got some
sorry.
aspirin right about now.
Jenna, will you just note that we did close the public hearing, so we'll have to reopen it at the next date? Thank you. All right. Wow, we're really working hard tonight. Moving along, appeal number 2024-021. Susan Batista has petitioned for a variance pursuant to section 240-85A. Permit required section 240-85B, illegal signs, section 240-71, signs in the DMS, section 240-65A, number of signs per business, section 240-65C, total square footage of all signs, and section 240-42, Hyannis Main Street Waterfront Historic District Commission, B2, approval required. The petitioner seeks relief from square footage and total number of signs. Petitioner seeks to have 3 signs where 2 are allowed and seeks to have 87 square feet of signage where 50 square feet is allowed. Subject property is located at 525 South Street, Hyannis, Massachusetts, as shown on Assessor's Map 308 as Parcel 162. It's located in the downtown Main Street DMS zoning district. So again, sitting on this will be all members present. Ms. Batista, go ahead.
Okay, thank you very much. Anyone need to stretch or anything, get up? Well, thank you very much. I'd like to introduce myself. I'm Susan Batista. I'm the owner of 525 South Street, and I'm here with my husband, Fritz Kletke, my daughter, Ava Kletke, and residents from 525 South Street, Sophia Texera, Van Nichols, and Rowan Judge. And I think we lost, did we lose? And Odette just left. But we are a community of young adults with special needs who graduated from the Riverview School. We've lived successfully and independently at 525 South Street for the past year. And when we purchased the building, there was a tax office on the first floor, and that tenant decided not to continue the lease. So we saw that as a wonderful opportunity to create a community, creative, inclusive space for our residents and for other Riverview graduates that live in the Hyannis area. And we enjoy that space with yoga classes, dance classes, we do performances, art. We have an art gallery where our residents show their work. And we really try to bring the joy of creativity to Hyannis. It's a very prominent lot. It sits up on South Street. It's very visible. The entire front facade and wrapping around the side is all glass. The condition of the building is it's broken up by windows. So when we installed signage, it was very important that we were creating a scrim or screen to shield what we were doing inside from the outside, so we weren't on full display. Anyone going down South Street, all you see is the windows and, this building. So it was very important, given our population, that we had some kind of scrim or screen to let the light in. It's beautiful to have windows. It's beautiful to be there on the main historic street there, the main street, but we given our population, did not want to be on full display. So we worked with a very talented graphic designer. Our name is Hyphen, and through visual graphics, created a scrim and also incorporated our name into the facade. The facade is broken up by 3, I don't know the correct term of windows, mullions or something, so it's kind of split into 3 parts. So it's HYPHEN fitting across the 3 windows in the scrim, really quite beautifully. It's a joyful blue color and the historic color, and it served us very well. There was also a freestanding sign, I think you've seen the pictures, that was in very bad condition that we just painted and made look nice. So I did bring the community here with me because they did want to say a few words. This is the second time we've been in this room speaking and advocating for ourselves, and it's a really wonderful life skill that they understand how a town and a government work. So if I may just have them say a few words about the space and how important it is to them, and why the way the signage is, it's about keeping everyone safe, using the space we'd like to use it in. We think it's an incredible improvement from the previous condition. We did reduce the signage significantly from the previous tenant. That's why when I got the call saying we were doing something wrong, I'm like, what? We actually have less signs. So that was a surprise to us. But I did want to give them the opportunity to speak before you as well. Thank you. So would anyone like to say a few words? I know Sophia would.
Just introduce yourself and say your address for the record.
Hi, I'm Sophia. I'm a resident at 525 South Street in Hyannis. As Susan says, Hyphen is a very well-known space for kids with disabilities to be able to use and be a part of. I do use Hyphen quite a lot in the last couple years that we've been here. It's been a very teachable moment for each one of us. And getting rid of Hyphen sign would not be able, we wouldn't be able to be where we are today without it, and be able to use that space and be inclusive with kids with disabilities, including me. And I would just like for Hyphen to stay that way and be able to bring everyone else from the community in and be able to be a part of it. Thank you.
Thank you.
Hi, I'm Van Nichols, and I am also a resident at 525 South Street, Hyannis. And a lot of us really like the Hyphen sign, and we do lots of activities in Hyphen. And I think it really helps, like, for like other people to see like that there's that Hyphen's on the window there, and it shows like that there's like an art gallery and other types of stuff we do there, and for other people, friends and family that we invite over, it also helps them find our building because it's right there and by Main Street, and I feel like without it, it would be really hard to find our building if the sign wasn't there or anything, and it would just be difficult for other people to find other people, friends or family that find our building if we were trying to get them to come over and look at our art and stuff.
Thank you.
Would anyone else like to speak? Ava, do you want to say something?
Sure.
Okay. Say your name.
My name is Ava Clarky, and I'm a resident at 525 South Street. And one thing I like about Hyphen is the yoga class and the Cape Cod social and karaoke and
Use in a lot of different ways, right?
and Hyphen opening, and I want to keep Hyphen is the way it is. Thank you.
My name's Rowan, and what I like about Hyphen is it's like we can use it for like all different activities such as yoga and art socials and galleries, and like what everyone else said, I just think it would like make it a lot more noticeable if the sign stayed. So thanks.
Thank you. It was so nice that everyone spoke. It's so important to speak. So now we'll talk about the criteria and talk a little bit more about that. And this is Fritz.
Yeah. Hi, I'm Fritz Kletke. I'm Ava's dad and Susan's partner. Anna, could you pull up the image I sent? I think it addresses number 1 quite clearly. Yeah, the one I just sent most recently. I took it right before we walked over.
No, not that one.
No, it was one. Yeah. While I was sitting here. I took it right before we walked over.
Oh, you might not have it yet. Why
Oh, I
don't you
don't have
show
it?
them on your phone?
Can I approach?
Can we approach the bench?
Yeah, we have to put it into the public record somehow,
Yeah.
right? Anna, did you email it to Anna?
Yeah.
But if we see it,
Okay, we'll just show them on our phone if we can approach the bench.
yeah, that's fine, yeah.
So this is, just want to show the conditions. This is South Street, and this is Newton Street. This is the sign in question. As you see, it's totally, that's the sign in question. So
Just go back to the microphone to keep talking, just so it's on the record, please.
Okay.
Thanks.
Keeping that in mind, I think it addresses the shape and typography. So the topography is such that South Street is raised up. So you're looking kind of, as you walk by, you're looking straight in. And then it slopes up to Newton Street, where it's at grade level. So you have, from both of those directions, you have people walking by, kind of looking straight in. And as the residents mentioned, people are often doing yoga, partially dressed, whatever. They can look straight in, and so that front window kind of acts as a screen. But it directly addresses the topography of the land is part of the issue. Like, if you're looking at this, you're looking straight in through at eye level, right at people, right at kind of their waist level. And then the other side on Newton, where it's the full plate glass windows, you're looking straight in. So that topography of the land, check.
Requires that we have a scrim, yeah.
The second one, literal enforcement of taking this scrim off, taking this would, as the resident stated, allow them not to use this space. This space is not a for-profit space. This space is used, as you've seen by the letters that have been submitted by a number of arts organizations. It's a community space. But if it didn't have this scrim here, if it didn't have this kind of covering over these large windows, it would not function as a community art space at all. You could not have yoga, dance, things like that, having that just all open to a main street like that. And number 3, I think, would definitely not have detriment to the public good. And I would hazard to say that having hyphen there as a kind of anchor on the end of South Street in the West End is a public good. We've contributed, we give free space to all these different organizations that have events there, yoga classes, karaoke, dance classes, drumming, art openings, all free, all open. We don't charge for the space. So I think it's, going beyond just saying, would it be a detriment to the public good? No, making this hyphen space less usable for the residents and all the people who come to it would be a detriment to the public good. So thank you for your time.
Yeah, and we had lovely partners who donated a lot of the work to create this. So to recreate it, I don't know that we could do that as well. So thank you.
Thank you. So I just have a couple of quick questions, just to give clarity here. So we've got the blue sign outside, the wooden sign that was there historically.
Yes.
And then the building commissioner is measuring the sign on the window, the blue.
Yes,
Calling that the second sign.
yes, they're measuring that as the second sign, and they're measuring the height up to the top of the H. So the scrim really goes to the crossbar on the H, but because the two H's are lowercase h's and they go up, we had to, draw a pink bar across that, and that's really the area they're considering it. But it's really only half the window. It's just the H, the top of the H that goes above, and that's what made it go out of compliance.
Okay.
Those one blue lines that are at the top of the H triggered this.
And then I guess my next question is, are you opposed from going to the Main Street Waterfront Historic Board for approval? That's just sort of the standard for any signs, no matter what they are in the district.
I was advised to get the variance first and then go to them, because
yeah.
without the variance, it wouldn't matter, so.
Yeah, just the
And
relief
that'll
that
be
you
the next
asked for
step.
was, the way I read it, was for us to waive that as well.
Oh,
And I'm just asking if we grant the number of signs or something of that nature, but we still say you would have to go to historic to get approval, you would be okay with that?
oh, absolutely. I kind of assumed I did, so.
Okay.
Yeah, that would be fine. I mean, if we could do it all tonight, that would be better, but.
Yeah. I mean, again, we have a variance here in front of us. I mean, I don't know the Dover Amendment well enough to know if it would qualify there either, but.
Is it going to close public?
We haven't, does someone want to, I'll open public comment. Does someone want to go through the letters, or do I need to? Is anyone ready to? Okay, I can do it.
There's one letter that's particularly beautiful, if you want to read Antonio Stevens' letter. I think we got quite a few letters, but hers, I think if you read it, that really conveyed the essence of everything. And she's really a well-known and respected community member.
I'll try, someone check and make sure I get them all, the ones I have opened here. The first one was from the Hyannis Main Street bid from Elizabeth Wharfbane in support of the signs, dated June 12th, 2024. Antonio Stevens did write a very nice letter in support as well, and detailing some of the graphics and the artistic characteristics, and she is the director of the Hyannis Public Library. And then we had another letter in support from Odette Perez and Odette Besso. We had a letter from David Kewen, the executive director of Kewitt Center for the Arts, in support. We had a letter from Leanne Judge in support, and Stephen Judge as well. We had a letter from E.M. Dirks and Clint Mason in opposition to any further changes or allowances that promote encroachment into the historic neighborhood as it's happening at an accelerated rate.
Yes, and may I make one comment on that? Anna, can you pull up the submission I had of the two images from Miss Elizabeth Deary?
It's in the public comment folder, Anna.
So overwhelming support. The only person who has responded negatively to this, you can keep going to the images there, yeah. This is what her signs are on her property.
And that's why I just read the letter, just to give it context. It wasn't just a letter in opposition. It was sort of not specific to what you're asking for, but more broad to the neighborhood or the historic district. Additionally, we had another letter in support from Amy Brenneman. And I think that's all of them. Did I miss anyone? I think I got them all. Is there anyone here to speak to this? Anyone else want to speak? Seeing none, I'll make a motion to close public comment.
Second.
All those in favor?
Aye.
Aye.
All right, so public comment's closed. Do we have any more questions for the applicant? I think we need to just think this through here.
Where do they come up with the 87 square feet? Part of that must be the freestanding sign, and then somehow,
Can you
you're not
pull
taking the
that up,
entire
Anna?
area.
Yeah, I want to be very specific for you. So, so there's a sign on the front. There's a sign on the side, so we're just trying to close, where people are looking in, and then the freestanding sign. So we go from 2 that are allowed to 3, and then, do you see how the scrim is actually below the top of the pink, but because of the height of the H, that's where we had to go up, and that's kind of what drags it up to go over the square footage allowed.
So they're not counting the thing, there's some pictures in the building commissioner's report that has, like lettering on the inside of the windows, like on, those are not counted? Or they
No, those are counted. That's
Those
what
are
you're
counted.
looking at. Yeah.
Okay, so that's just in the pink area?
Yes.
Okay. So the hyphen that you showed in the other picture, okay, there we go.
So see how the scrim is fairly low, it's only 33.5. So initially, I'm like, wait, we are in compliance. But then someone, probably Anna or Gina, told me, no, you got to go up to the top of the H. And by doing that, that's where we went out of, So it seemed like, I don't think that's, the other 2 signs are just advertising signs. Those come down. Those are currently not up. So it's just where the hyphen word is on the front that they're saying is too big, and it's because of the capital, or the lowercase h ascender.
Okay.
Is it a sign or is it art?
It's just a vinyl
don't know.
graphic.
Who created the sign?
My very talented husband, Fritz Kletke, who's a graphic designer.
I would call the left middle window art.
Yes, it's an art gallery, so one would
Well, that
call
was
it
Mark's
art.
point. Is it a sign or
Yeah.
is it
A
art?
sign or is it an art? Because
That's kind of,
Public hearing.
yeah.
No, just public comment is. We didn't close the hearing yet. Just public comment.
So,
does that cover the difference in the H?
I don't know how close, my math's not that good, but,
And the sign that was there before, they went all the way from the bottom to the top of the window, and I did submit those as well. When it was a tax office, they
the shape of the
covered the entire window, and nobody, brought them before this board, said, something's wrong. So,
visual,
we feel kind of singled out on that.
and they're calling that 2 signs, the hyphen, and then the left side is 1, 2, and the wood sign is the third.
Good question. It's been confusing. When I first was speaking to people, they're like, that's 3 signs. And I'm like, what? No, that's one word. It's just the building is broken over 3 panes of glass. So I think I got everyone to agree that that's one sign. And then the second sign is on the side of the building. And Anna, I think we also have an elevation of that. And then the third sign is the freestanding sign that we inherited. That's the side on Newton Street. And it shows that that's at,
it's not a sign.
yeah, and see how hyphen is just, we had to make that, because it's a, we didn't want people to be able to look in, so that's why that's higher.
I mean,
And then
that's
there's a
like barely a
freestanding
sign.
sign.
Wait, can you go back to the other one, Anna, please? That one right there.
So that's just the stuff in the window, but it has your name on the bottom of it, basically.
That's exactly right. Yeah, and it's really meant to be a scrim so people can't look in, so that's why we would put the 6-foot-tall person there. I know, thank you.
Okay, so
There-
again, we have to figure out how to make this work. That's just like worst case scenario, I think if you did, if we couldn't get there, if you took the hyphen off of that, it wouldn't be considered a sign. If we got to a point where we need to do that. And I don't know how important is 2 signs allowed? 2 signs allowed in the DM, right?
It's more important when they go two-way with South Street. I mean, then,
Yeah.
to get the traffic two-way, so.
Well, I don't agree that second pane is a sign. It doesn't advertise anything. It's just a picture.
It's almost directional,
Yeah.
or like, I don't
Yeah.
know, it's like,
Yeah.
Thank you.
and they're calculating that whole square footage too, of the whole scrim there.
Which is almost 10 feet, so.
Okay, so how do we get to yes? Who wants to go for it? Or we have to close the public hearing if we're ready. Go ahead.
Who created the hyphen?
Husband designer.
My husband, he's a designer.
I see where Mark's going with this.
We actually,
If you would go to the next one, which I think is the one that we really have, is that a sign?
That one.
Yeah, I mean, That's a screen for the window.
It's just kind of, yeah, to obscure
Yeah,
people
that's
from
what I'm saying.
looking
If it didn't
in.
say hyphen on it, I don't think the building commissioner could argue it was a sign. And either way, the left part of it's not a sign. It's like tinting. You can call it window tinting.
I could argue on slope.
So what is the square footage of the signs without the second pane with the artwork in it?
I don't know what's that.
Approximately.
What is
I
it?
think we have that
67
calculation.
by.
If you want to pull that one back up, the front one you're talking about without, yeah. That is,
Let's see.
yes. So the total sign there is 57.5, and I think we're allowed 50, is that correct? So we're over just by a little bit. And that was just because the H's went up a little bit higher.
So 2 signs are allowed and 50 square feet is allowed.
Right.
It's 50 square feet combined between the 2 signs, probably?
I would guess, yeah.
That was my question, because they're on 2 facades. One's a front facade and the other one's a side. So
Is the
can you break
total
that up?
signage the front and the side, or is it just what is indicated here in the pink?
The total that went to 80 is the front and the side. The pink here is 57.5, and that's the front.
I see, okay.
So
Yes.
if you remove the hyphen from the side and considered it the scrim and considered it not a sign, it still is exceeds the allowable?
By 7.5 square feet.
I mean, or can we just give them the variance on
I agree.
topography
I
of
think
the,
it's topography.
of the,
Yeah.
I'd
the
say
location
topography.
of where it
Yeah,
is?
I say topography.
And
And the hardship is clear.
yes. And none of the signs are, it's not like they're asking for a big sign out on the street.
Doesn't
Which
look-
I feel that's the intent of the bylaw is controlling signs that are,
Precisely.
oversized out
Yeah,
on the
so it
road.
doesn't look like, I agree.
So should we close the public hearing and,
Yep.
all right, so I'll make a motion to close the public hearing.
Second.
All those in favor?
Aye.
Aye.
So the hearing's closed, back to the board. Someone want to make findings, or who wants to go for it? And then I guess the other question is, I don't think we've ever done it, but do we want to waive historic, or do we?
Wanna
I think
what?
Waive
What?
historic? It was asked for, I believe.
Are we allowed?
I don't know. And are we allowed to
didn't
waive
see it.
historic?
It doesn't
I
say
don't think
waive.
You are.
Okay. Okay.
Oh, okay, I see what you mean. Do we have the
And-
right to waive it?
Hyannis said she doesn't think we do.
I agree, not
Okay.
from what we heard today.
Wait, the what?
Them having to go to historic. They have to go to Main Street Waterfront Historic for signs in the downtown.
Oh, I see.
They're in the historic district.
They're in the Waterfront Historic District.
I wouldn't think we could, but
So it's a condition.
Okay, so I just want to be clear what we're giving relief for. We're
Right.
giving relief for, she's going to file a permit for it, so we don't, right? So we don't have to give her relief for the permit required. We're making the signs legal, so I don't know if we have to make,
Total square footage.
it's really for number of signs and total square footage.
Correct.
Right, yeah,
Those are the two things that we need to get relief for.
correct.
So we'd be giving relief for there to be 3 signs, one more than allowed, and 37 square feet over what's allowed. And I think we should probably reference to what's been displayed. So that would mean that if you guys did want to change, I don't know how much we want to condition it, at least to those boxes, most likely we would condition. So if you decided you wanted to do other,
You talk about the side of,
I mean, I guess if they wanted to
Like if the
move
font
hyphen over
changed
to the
it.
right windows as the same size, it would be allowed.
Just can't occupy more space. It's at the
So
same.
just leave the same
It's at the
square
same
footage?
height. It's at the same everything.
What you'd have to do is take the hyphen out of the side window, so it's not considered a sign, so therefore you'd have two signs.
Excuse me, that sign can't be moved to that left window. There's a bullet hole in that window.
Well, we're just talking about like future forever and
I know,
ever, like
future.
even when we make a variance, that's gonna transfer with the property forever,
Got it.
potentially. So, in 100 years, someone could have a huge, who knows what sign there.
You
that they
give
wanna put.
hyphen away to somebody, you donate it to somebody, they may have a different use. It follows.
Got it.
But we also we can't condition a variance to current owner occupant.
That would work.
So I guess it's just how you want to. What's everyone's comfortable with? Who wants to go for it? I've been talking all night. Mark, Herb, Paul?
But I'm still hung up on the three signs.
Do you want to make it two?
Yeah, I want to make it two.
Okay.
And so I would, if we remove the hyphen from the side single and just put continue with whatever is there,
The scrim.
that effectively.
That would be a bit of a financial hardship because we'd have to remove it and get a new one printed and put up. You just can't cut it out. It's a piece of vinyl.
So a razor blade doesn't do it.
It would start to peel and come off. Those things are not, they're vinyl graphics. They're not meant to be forever, so you can't really play with them. It's really subtle. I mean, you can barely see it on the side.
I know, but,
I know.
and it's a sign, so.
And it is kind of like an entrance, so people know to come in there.
Put an arrow, it's a directional.
Put an arrow over it.
Yeah.
It's an entrance.
Or an arrow above it or next to it.
On the outside.
I mean, we
color.
can't speak for the building
We're
commissioner.
hyphen,
No.
not arrows. I mean, we're very specific in our iconography.
I'm just thinking of the side. Okay?
Yeah, it's so subtle.
I know, that's that's why we're sort of frustrated, because it's not really a sign.
It's
But the
not
building
really.
commissioner has determined that he's calling it a sign at this point. And I'd have to read the DMS bylaw, but I think a number of directional signs would be allowed. It's sort of saying if there was an arrow above it, like it's
Okay.
directing people, when it's a directional sign, it falls outside of
Okay.
these.
We could
So
add
maybe
an
we could
arrow.
Do that. Again,
Yeah.
we can't speak for the building commissioner of how
Can
he's going to
someone
interpret
pull up
this.
24071?
Mm-hmm.
Do you have that?
247, 247-1.
No, 240-71. Or 240.
Oh, yeah, here you go.
Well, they asked for 85.
Two,
Here's something right here.
Yeah, okay, so, well, then in the DMS district at 71 is the sign specific to the DMS district.
yes, yes. Well, that's DV. 240-71 signs in the downtown
Maximum square
village.
footage of all signs shall be 50 square feet or 10% of the building face, whichever is less.
12 feet.
Building face goes 3 stories.
Yeah, so it's more than 50 feet. So it's limiting it at 50.
Okay,
Maximum size of any freestanding sign shall be 12 square
60
feet.
65.
Yeah. I mean, if you saw it in situ, the scale is really correct for the building. It doesn't look oversized. It doesn't look undersized. I mean, that's kind of what Fritz does for a living. The scale of it is kind of perfect. If it was smaller, you wouldn't be able to see it, and if it was obviously bigger, we wouldn't do that. So I think we really hit the scale right.
We did give a variance at one point, I believe, for the distance. It was scale last time we did it with the
One of them's directional.
floors and
It
walls.
says
You weren't going to be able to
defined
see it from the
signs.
street.
Yeah.
This could be the same if you make it too
Well,
small.
I think that's the variance argument, that the
65.
topography of how the building is
Right.
up and
Up to
set
two
back.
directory signs.
I mean, how important is the problem is they still have to go to historic. How important is the blue wooden sign? Is that,
It,
I mean, I know signs are really expensive, but
yeah.
So the blue wooden sign, as I showed you, the photo I took right before we walked over here, the one in question, this blue sign on the windows, which I call a scrim, is completely obscured. So right now, like in prime season. So you can't even see this sign at all once the trees come out.
Yeah.
So that's why that
have
that
new signs
freestanding sign is key,
Okay.
which was in disrepair before
Yeah,
we fixed
yeah.
it.
Yeah,
So
it's kind of a condition of the topography of, where it sits. So in winter, it looks different than summer.
I mean, I think it also could be argued that on the side one, the sign, the actual sign dimension is just hyphen. The scrim is not sign.
No, it's not.
But we can have,
If there were an arrow above the pane on the side I'm talking about, pointing towards the front of the building.
Towards the
right,
door
the
or
entrance.
wherever
Then it
your
would be
entrance
considered
is.
a directional sign.
That would be a directory sign, and it shall not exceed 20 square feet. It seems to me, if there were an arrow there, I would classify it as a directory sign. And so the only thing we're talking about now is
The 7
exceeding the
square feet.
footage.
7.5 square feet,
Correct.
yeah.
okay, just some,
It might be argued on the square footage based upon the slope of the land. Let me think this out here. The slope of the land requires
the topography of it being raised.
topography, topography of slope requires shading for its current, for the participants, the activities, the artistic activities inside, so that people can't stand out there and stare in the windows.
That it's a privacy screen. Okay.
Privacy screen.
I mean, I think we could, probably exclude some of the square footage that the privacy screens are not signs,
Right.
too.
Oh, yeah.
Okay, so who wants to make findings?
Well, I'll take a shot at
We
it.
close the public hearing, yes? Yeah.
Yeah, take a shot at it.
Go for it.
Okay. This is appeal number 2024-021, 525 South Street Community LLC. Susan Batista has petitioned for a variance with respect to signage. The board, the issue is that the, hang on here for a minute. There are 3 signs where 2 are allowed, and there is 57 and a half square feet where only 50 feet is allowed. The subject property is located at 525 South Street, Hyannis, Mass. As shown on Assessor's Map 308 as Parcel 162, is located in the downtown Main Street zoning district. The first test is owing to circumstances related to soil conditions, shape, or topography of such land or structures, especially affecting such land or structures, but not affecting generally the zoning district at which it is located. I find that the circumstances is related to the topography of the land such that passerbys can look into the windows and see exactly what's going on inside. And some of those things want to be screened from the general public. Therefore, it is the slope of the land that requires some screening of the windows. Number 2, a little enforcement of the provisions of the zoning ordinance would involve substantial hardship, financial or otherwise, to the petitioner. I find that the elimination of these privacy screens would force the discontinuance of a number of activities, artistic activities that currently take place at this location. And I believe, therefore, that the ramifications that would follow from that would be a severe hardship. Number 3, desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the zoning ordinance. I find that there is no derogation of the intent and purpose of the zoning ordinance. The signs are artistically and professionally created. They serve a specific purpose. They are not lit. They are, nothing draws your attention to them outside of a normal window sign. Those are my findings.
All right, Paul's made a motion to approve appeal number 2024-021 based on the following findings. Do we have a second?
Second.
All those in favor?
Aye.
Aye. So now conditions,
I
Paul.
have conditions 1 through 3, and those are okay with the applicant?
Yes, thank you.
Yeah, I think we need to add a fourth here. I'm just worried about the future. So I'm just saying maybe that
Mr. Chair, did you remove one of the signs to make it 57 square feet and not 87 square feet?
No, we said we were going to put an arrow, right?
An arrow in
This- so the side-
replacing,
this-
replacing one of the signs.
No, not replacing, adding an arrow. 'cause it's
Turning the
directional.
one on Newton on the side street to become a directional sign
Yeah.
by making it an arrow towards the entrance.
And that should be a condition.
Yes.
Yep.
So we can,
It's just adding an arrow, right?
Yeah, just like put it above.
Yeah.
Like if you can just get another, I mean, you could get a piece of vinyl or something and stick
Okay,
it above
we can
it.
do that.
so in number 2, Anna, we want to, I think, add to that, the proposed signage shall be constructed in substantial conformance with the plans included in the petition called South Street View and Newton Street View, plus the conversion of the side privacy screen to a directional sign. So is that, what
Yeah, and then-
street is that on?
Newton Street.
Newton Street.
Yes.
And then I guess my concern is like someone in the future taking all this sign square footage and making a big sign in the front. So I would just say that,
We can constrain it to the current.
that it would have to come back to the board. Yeah,
Yes,
it would have to
right.
come back to the board.
Right, that would be number
So-
4.
Yeah, so no changes.
No, wait a minute, the waterfront district.
That, they have to go to waterfront. We're not giving them relief on that.
Okay, so in number 1, then we want to strike section 240-42 Hyannis Main Street Waterfall Historic District. Let me read this again. This is number 1 condition. Variance number 2024-21 is granted to Susan Batista for a variance pursuant to the permit required section illegal signs. Section 240 is the DMS, section number of signs to business, section the total square footage, and section 240, no, we want to strike section 240-42 Hyannis Main Street Waterfront Historic District Commission B2. In other words, you still have to go there.
Yes.
Okay.
Will do.
So Anna, we want to strike that last part of that sentence out.
And then, Anna, should it be granted instead of to Susan Batista? I assume the ownership of the
To the
property is
LLC. Yeah. 525 South Street Community LLC.
Right.
And so then you're saying, so then, Paul, so then going on, and total number of signs specifically to have 2 signs and 1 directional sign?
Yes.
And what does that put our square footage at, did we determine, or do we have a, Mark, did you come up with a number of square footage? If we're removing the directional sign?
No, it's 57.5
Okay.
square, instead of 80.
Why don't we say approximately 57.5, but
Yep,
as it exists, subtracting the Newton Street,
right.
what the building commissioner counted.
So number 1 would read at the end, to have approximately 57.5 feet of signage, eliminating the Newton Street
To making it directional. Yeah.
definition of sign. I'm going to go get this one wrapped up, don't I? Hang with us a minute.
Thank you.
Okay.
And then I guess my only last thing would be just that the road sign can't change from existing size without coming back to the board, which is just looking out for future owners or,
None of the sides can be increased.
but including I feel like we're leaving it open for them to remove the vinyl sign and then increase the size of the current blue road sign. Like, not for
Right,
them
right,
necessarily.
right.
I know they have no
Understand,
intent to do that, but I'm
understand,
concerned in the future if that became a,
But
whatever.
there are, in the code, there is a specific size for the signs, for the road signs.
Yeah, it's a freestanding sign,
Yeah.
and we're within the
Yeah,
criteria
there's
for that
specific,
particular sign.
Square footage.
Yeah.
so you don't think us giving them up the ability to go to 57 square feet would allow that sign to become 57 square feet?
Oh, you don't want them to increase the sign because it's the size of the sign because we already gave.
Because we
them-
gave
Okay,
them,
all right.
just
So-
without
all
coming
right,
back to
no,
the board,
Yeah.
but
all right,
again,
all
I just don't want, whatever, Dunkin'
Number-
Donuts to go in there someday.
So
and they-
number 4 would be the,
The
There's a
freestanding sign,
yeah, the freestanding, I know there's the freestanding sign,
To remain at existing size without coming back to the board.
right.
yep, that,
That's,
here,
again, variances go with the property forever and ever, so we
Yes.
just don't know who the next owner will be.
definitely.
All right. So,
I think we got
Anna,
it.
Jenna, you feel comfortable? Did we give you? You got that? Okay.
Okay.
Send it to Paul when you write it up. All
Okay,
right, so.
those are my conditions.
Motion to approve with the conditions presented by Paul. All in favor?
Aye.
Aye. Opposed, abstained, none. All right, so you guys are set.
Thank you very
Jenna
much.
will be in touch, and
We
then
appreciate it, and thank you,
Historic.
Jenna and Anna, for your patience with us.
Thank
We're
you guys
new
for your
at this.
patience tonight. It's been a long
We
night.
are new. Thank you.
Thank you.
so much for listening.
Get that arrow up there.
It's really great for them to see how a
Oh,
government works.
Yeah.
We appreciate it.
No, thank you guys for speaking and being here.
I'm sorry, thank you for the notes. That was good.
All right,
I knew there was-
does anyone need a break, or are we good to go? Okay, last one.
I need a water.
Appeal number 2024-025, Luongo Real Estate LLC has applied for a special permit pursuant to section 240-91H3, develop lot protection, demolition, and rebuild of non-conforming lots. The applicant proposes to demolish the existing single-family dwelling and construct a new single-family dwelling with detached garage. The existing dwelling has non-conforming front yard setbacks on Fifth Avenue, 16.6 feet, and Birch Drive, 11 feet, where 20 feet is required. The proposed front yard setback on Fifth Ave is 20.5 feet, which complies with zoning requirements, and the proposed front yard setback on Birch Drive is 18.1, which does not comply with zoning requirements, but is less non-conforming. The subject property is located at 222 Fifth Ave, Hyannis, Massachusetts, shown on Assessor's map as 245 as parcel 133. It's located in the Residence B RB zoning district. Sitting on this will be all members present. Attorney Ford, right? No.
It's Attorney Nickerson,
Attorney
Mr. Chairman.
Nickerson.
Thank you. Thank you, Mr. Chairman, members of the Zoning Board of Appeals. For the record, my name is Patrick Nickerson. I'm an attorney with the Law Office of John W. Kenny, with our office in Centerville. Tonight with me are 4 gentlemen. To my left is John O'Day from Sullivan Engineering with an office in Osterville. To his left is Mike Tartamella from an architectural professional from the firm Patrick Ahern with offices in Boston and Edgartown. To his left is Attorney John Kenny, a man who needs no introduction. And then behind me is Michael Kahn, who is here from Patrick Ahern. He's assisted on this project and is here to observe the proceedings. Collectively, we represent Luongo Real Estate LLC, the owner of record of the property located at 222 Fifth Ave. That is comprised of 13,863 square feet, and it is improved by a single-family dwelling with detached garage and in-ground pool. Before I turn it over to Mr. O'Day to walk us through the site plan, I'd just like to provide a brief procedural history of the project. The applicant acquired the property in December 2020, and since then, it's been dealing with an infiltration of mold, water, insects, and rodents due to a cracked foundation and dirt crawl space basement. These issues were all identified pre-purchase through pre-purchase inspection reports, and actually the applicant obtained a certificate of demolition from the Historic Committee prior to purchasing the property. It's always been their intention to tear down and rebuild the single-family dwelling, but due to delays in planning and COVID and everything else, plans were put on hold. We were able to get a renewed demolition permit from Historic Committee back in March of this year, so it is still active. That being said, I'd like to turn it over to Mr. O'Day to walk us through the site plan, which will show both the existing house as well as the proposed house on the lot. Mr. O'Day?
Thank you. I'll be brief on this. The project as proposed is to demolish and rebuild the dwelling. As you can see on the site plans, the mass of the dwelling is generally in the location of the existing building. In the design of the footprint, which was really more the architects, I think that the guidance that we gave them was to try to come up with a development that does not worsen any of the setbacks that we have on site. And again, we are dealing with setbacks to Fifth Avenue, Birch Ave, which is a paper road, or Birch Drive. We also have wetlands to our east and a septic system along Fifth Avenue. They've come up with a footprint that actually improves the setbacks in every respect. We ended up actually with a reduction in square footage in all the conservation buffer zones. We've been before them, received an order of conditions. Really the big improvement on the zoning is the most northerly end, probably where the existing dwelling was located within in close proximity to both Fifth Ave and Birch Drive. And so by pulling that down and centering the building more in the lot, certainly able to make improvements on all fronts on this. The garage is being generally rebuilt within existing footprint, and same with the pool. So the accessories are kind of staying generally in their existing footprints. Mass of the house is really staying where it is, and just kind of trimming off what was probably historically some addition up there on the north end that's too close to Birch Drive right now. I think that's the brief summary of it. We did have all the lot coverages on our site plans, and as it indicates, we are falling within and below the existing lot coverage on the property, and the floor areas were also well outlined on our site plan as taken from the architecturals, which I think were submitted with the application as well. So I'd be happy to supplement any questions you may have.
Just a very quick question. Is Birch Drive, I'm just not familiar with this particular road. Is Birch Drive a paper road? Is it a non-traveled road at this point?
Paper road. There is
Okay.
nothing back there.
So one of your setbacks is on Birch? Just one of them, right?
The
18.
only one that is requiring the relief is to that paper road. 18.
The whole idea of the relief is really...
Yeah, well, it's a special permit. What year was it built, the existing home built?
According to Assessor's records, it's 1940.
Okay.
We had a GIS map included in your packets from 1951 or 1952 showing the single-family dwelling, the pool, and the detached garage were added after the year 2000. It does have two front setbacks on Fifth Avenue and Birch Drive. The proposed dwelling will comply with the 20-foot front setback on Fifth Avenue. So it's right now it's 16.6 existing. The proposed is 20.5. On Birch Drive, it's 11-foot existing setback. It's being increased to 18.1. So despite it being a paper road, we're reducing the degree of nonconformity with regard to that front setback. But since it's not 20 feet, we would need the special permit because it does not meet the 20-foot front setback. Despite it being a paper road, there's no exception for a paper road in the ordinance. If I could just give you a brief summary of the zoning related to the property.
I was just making sure it was legally non-conforming.
Yes.
But I mean, it's pretty straightforward.
Straightforward. We can make...
I think.
Okay. I was surprised when I went down Birch Road.
All right, so let's just open for public comment. I don't think we received anything on the, Attorney Kenny gave us a letter of support. Anyone else to speak to this? Motion to close public comment?
Motion to close public comment?
Second.
Second.
All those in favor?
Aye.
Aye.
All right, public comments closed. Do you guys have anything before we close the public hearing?
No.
No? All right, make a motion to close the public hearing.
Motion to close public hearing.
Second. All those in favor?
Aye.
Aye. All right, does someone want to make findings?
I can give it a go.
Go for it.
With regard to special permit number 2024-025, Luongo, section 24091H3, develop lot protection, demolition, and rebuilding on nonconforming lots. Luongo Real Estate LLC has applied for a special permit pursuant to Section 24091H3, developed lot protection, demolition, and rebuilding nonconforming lots. The applicant proposes to demolish existing single-family dwelling and construct a new single-family dwelling with detached garage. Existing dwelling has nonconforming front yard setbacks on Fifth Avenue, 16.6 feet, and Birch Drive, 11 feet, where 20 feet is required. Proposed front yard setback on Fifth Ave is 20.5 feet, which complies with zoning requirements, and the proposed front yard setback on the Birch Drive is 18.1. which does not comply with zoning requirements, but is less nonconforming. The subject property is located at 222 Fifth Ave, Hyannis, Mass. For all special permits, the board is required to make general findings pursuant to 240-125C. The board should review the evidence presented by the applicant, staff, and members of the public, and after weighing such evidence, is encouraged to articulate if and how the evidence contributes to each of the required findings. Number one, the application falls within a category specifically accepted in the ordinance for grant of a special permit. Section 24091H3 allows for the complete demolition, rebuilding of residents on non-conforming lot. Applicant has shown that they have already acquired a demolition permit from historical dated as...
I'm sorry, I can have it for just a second.
As presented. Number two, site plan review is not required for single-family residential dwellings. Number three, after an evaluation of all the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or neighborhood affected. I find that they have shown that most of the setbacks have been improved based on what the original dwelling was. Birch Drive is only a paper road, and so there is no local access along that road, which would be a detriment to the public good if it were too close. Further, Section 24091H3 requires the board to find that if the proposed demolition and rebuilding cannot satisfy criteria established as H1 as of right, then the board may allow the demolition and rebuilding by special permit. Number four, the proposed yard setbacks must be equal to or greater than the yard setbacks of the existing building. Proposed front yard setback and side yard setbacks are greater than the existing. The proposed lot coverage shall not exceed 20% or the existing lot coverage, whichever is greater. Existing lot coverage is 22% and proposed lot coverage is 21%, shown as a reduction. The floor area ratio shall not exceed 0.30 or 30% of the existing floor area ratio of the structure being demolished, whichever is greater. Existing FAR is 21.6% and the proposed FAR 29.97%. Building height in feet shall not exceed 30 feet to the highest plate and shall contain no more than 2.5 stories. Proposed height is 19.6 feet to the top of the plate.
Is it 2 stories or how many stories?
I think it's shown, I don't have the drawing in front of me there.
Okay.
Referred to it as 2. According to assessor's records, the existing structure is also 2 stories. It's not.
Okay. As shown in the elevations presented by the applicant, board is also asked to find that the proposed new dwelling would not be substantially more detrimental to the neighborhood than the existing dwelling. I find that it is in conformance with many of the other structures and dwellings in the area, as tastefully designed with aesthetic of a coastal aesthetic in mind. Those are my findings.
All right, Mark's made a motion to approve.
I'll second that.
Herb seconds, roll call vote. Any findings? Aye.
Aye.
And conditions, Mark.
Yes.
Mark, I have a question on the conditions number 2. They're talking about the plan dated March 10th with a revision of April 8th. The plan we have, is this April 17th, isn't it? Didn't we find that?
No, that was another.
Oh, that was another one. I beg your pardon. I beg your pardon.
That was another one.
Okay, sorry, beg your pardon.
No worries.
I've been here too long.
Long night.
With
So
regard
1 to 6.
to staff report dated May 23rd, 2024, we have conditions 1 through 6?
6.
1 through 6. Have you and your clients had the opportunity to review those, and are they acceptable?
We have, and they are.
Okay. like to put those conditions forth.
All right. And vote on the conditions. All's in favor?
Aye.
All right. Attorney Dickerson, you guys are all set. Thank you very much.
Thank you. Good luck.
All right, what else?
Beat it.
Careful.
Correspondence, Housing Assistance Corp. Affordable Unit Monitoring Report dated May 30th, 2024 was received. Cape Cod Commission Upper Cape YMCA meeting notice for June 12th, 2024 was received. And Park City Wind LLC put in a notice of filing, request for comments, and public comment hearing for June 18th, 2024. Any matters not anticipated?
None.
Upcoming hearings, June 26th, that's on Zoom, July 10th in person, July 24th, back on Zoom. Anything else we need to know, Anna? Are we busy next month or not too bad? Oh, okay. All right, I will make a motion to adjourn.
Second.
All those in favor?
Aye.